So welcome everybody. Thank you very much for joining, those of you who are with us for the first time today, and thank you for coming back, those of you who have joined us for previous seminars in this series on business and human rights governance challenges in an era of transition. This is the fourth of our six-part seminar series, a framework treaty on business, human rights, interdisciplinary insights. My name is Claire Methven O'Brien. I'm a Baxter Fellow and lecturer at the University of Dundee Law School. I'm also convener of the University of Dundee's new Business and Human Rights Network and its newly established LLM on business and human rights. First, I should acknowledge the assistance of an interdisciplinary incubator grant from the University of Dundee Institute for Social Science Research. I should further thank this group of leading international experts we've assembled for today's panel, who've agreed very generously to give us of their knowledge, insights, and their time to serve as panelists today. And I'm delighted to welcome Professor Lorna McGregor from the University of Essex, Professor Maurice Altman from the University of Dundee, Dr. Axel Marx from the University of Leuven, Professor Brigit Toebes from the University of Groningen, and also Dr. Gale Raj-Reichert from Bard College in Berlin. Thank you all again very much for joining us. Today's seminar will feature lightning contributions from each of our panelists of about 6 to 8 minutes in duration, and we will have time at the end following that for questions and answers with the audience. So I do encourage those of you who've joined now to raise your hand at that point to ask a question, or indeed to place questions in the chat, as they occur to you, or at the end of the discussion. And then Ben will be able to come to you so that you'll be able to articulate your question in person if you wish. Alternatively, if that's not possible for you for technical or other reasons, we can present the question on your behalf. The last two seminars in the series will examine how a framework type business and human rights treaty or other instrument could be linked to existing business and human rights governance systems and processes, the wider business human rights governance constellation, and that will be held next Thursday, the 13th of October. And then the final seminar in the series will consider how to move the treaty process forward in a constructive direction. And if you would like to attend either of those subsequent seminars, you will need to re-register or register your attendance for each of those panels as you did for today's. And there's further information on the panels proposed and how to register, of course, on the website. And I think Ben is now posting a link in the chat to the Business Human Rights Network website. And through the contributions of the experts and scholars we're assembling for this series, we're really hoping to generate an interdisciplinary dialogue to explore key questions relating to the long-standing project to develop and conclude a UN treaty on business and human rights, and to highlight and explore the relative potential merits of a framework-style convention on business human rights, as I have proposed for some years, alongside the approach and text which have emerged so far from the Intergovernmental Working Group on Transnational Corporations and Other Business Enterprises. And just before handing over to the panel for the purpose of setting the scene for this discussion and for the benefit of those listening who may not be fully immersed in the business and human rights field, or specifically in developments and discussions around the Business Human Rights Treaty, I'll just say a few words now to set the scene and provide some background and context as regards that. And in the United Nations, there have been attempts to define international human rights standards addressed to business spanning several decades now, starting in the 1970s with the first efforts towards a draft code of conduct for transnational corporations in the context of the new international economic order. That was followed in the 1990s by an initiative to develop draft norms, UN draft norms on business human rights, in the context of the subcommission on the promotion and protection of human rights. Neither of those efforts ultimately succeeded in generating instruments which were as such adopted. In the 1990s, later on, of course, we saw a movement towards incorporating human rights into CSR. We saw the integration of human rights into the Global Compact, 10 principles, and one of the key architects of the Global Compact, UN Global Compact, John Ruggie, was then appointed by Kofi Annan as Secretary General of the United Nations to develop a set of guiding principles on business and human rights and a UN framework of 2008. And John Ruggie, of course, sadly passed away recently. In the UN Guiding Principles as a soft law instrument on business human rights have arguably had success, where previous initiatives failed in as much as they have been widely referred to, adopted, integrated both by business organizations, hybrid sort of entities, intergovernmental organizations, and states, of course, themselves through the growing phenomenon of national action plans on business and human rights. Parallel to the UN Guiding Principles and the work that's gone on to promote those in the private and public sectors, a parallel process was launched in 2014 to develop, again, a treaty on business human rights. But that seems to have struggled to make progress in the sense that key states remain outside the process. United States, for example, the European Union has had a sort of unclear relationship to the treaty process, you can say, up till now. And there is a perception that perhaps the treaty initiative has reached a kind of stalemate. So in that context, I reanimated a proposal that I'd made earlier for a framework type convention on business and human rights, which would be a legally binding instrument stating clear goals of the parties and commitments, the core obligations, establishing procedures for further standard setting across the swathe of business human rights issues that we see today. And of course, we'll be talking about some of those with our panel, and also providing for the establishment of institutions that could sustain dialogue, standard setting, oversight, monitoring, and accountability, but packing less content into the initial instrument itself than the IGWIG text has tried to do. And so far in the series, we've looked at framework conventions in other contexts. We've looked at the framework sort of approach from the perspective of other legal subdisciplines. And this time we're going to try to take a step back from the business and human rights treaty debate to really try to anticipate what are the current and also the future business and human rights challenges that such a global instrument would need to engage with and provide effective accountability or a bolster to accountability in relation to business and government actors. So with that, I think I will turn first to Professor Lorna McGregor, and we're hoping and looking forward to hear from Lorna more about the threats to human rights, in which of course businesses are thoroughly implicated, that are emerging and have derived from new technologies, digitalization, artificial intelligence, and associated issues. So thank you very much, Lorna, and over to you.
Thank you so much, Claire, and thank you for the invitation to participate in this really interesting event. In the 5 minutes that I have, I would just like to talk a bit about the work that I have been doing in relation to new and emerging technologies. So I am the principal investigator and direct a project called the Human Rights Big Data and Technology Project. And within that project, we look at the human rights implications good and bad, of the use of the design, development and deployment of data analytics and new and emerging technologies like artificial intelligence. And within that, we look at governance and regulatory solutions and approaches to remedies, both in relation to states and in relation to businesses. So the UN guiding principles on business and human rights are really central to our work. Now, within this sector, there is very clear recognition of the whole range of human rights implications posed by the design, development and deployment of these technologies. Initially, there was a focus on privacy, freedom of expression, and discrimination, and they remain sort of core risks to the use of any technologies. But there's also much greater recognition that depending on the context and the purpose for which these technologies are designed and deployed, any human rights can be at risk, and often multiple human rights are at risk. And we may often not know the scale and extent to which human rights risks are posed by the use of these technologies now or in the future. So within that context, there's really a growing view that self-regulation, if we understand that as major tech companies and other businesses working in the tech sector, there's a growing view that self-regulation, so these companies regulating themselves and voluntarily applying the UNGPs, is insufficient. But at the other end of the spectrum, we see a lot of concerns around forms of regulation that have been developed by states, like disinformation laws. We see a lot of concerns that they are really harmful to human rights, including in the actions that they require businesses to take. So between these two spectrums, there's really a question of what regulation could and should look like. And what's really clear in the tech sector is that we can't expect regulation to equate to one piece of overarching legislation, whether that's the treaty or whether that's a national or other regional piece of legislation. It is going to be what's often referred to as a smart mix of formal regulation, self-regulatory initiatives, and different thematic and actor-specific legislation. And that's inevitable given the range of technologies we're talking about, the power and the reach of the tech sector into our lives directly, and through the sale and partnership with states, so deploying these technologies in the public sector, and the scale, range, and potential human rights harms, which, as I've said, are not limited to privacy, freedom of expression, and discrimination. And that makes the approach of salient human rights issues quite difficult, because that can sometimes narrow the conversation about what needs to be regulated and how. So we will need a whole range of regulation, and some of that is being looked at, for example, at the EU with the AI Act that's proposed, as well as specific legislation on procurement in the public sector. At the same time, I think there can be a tendency to focus on the distinctiveness of the tech industry, and in doing so, overlook some of the core issues that apply across the business and human rights conversation. And if these conversations were advanced, it could really help the situation in the tech sector. And just to really highlight and to end, the crucial importance of mandatory due diligence. Now, whether that's adopted through a framework treaty, as Claire is proposing, or at the national level or otherwise, mandatory due diligence when we're thinking about companies' policies and ensuring that they're fully aligned with international human rights standards and norms, that they cover the full range of human rights harm, and that critically throughout the entire business, we can see a whole systematic approach to identifying and addressing potential human rights harms. And that includes impact assessments, but also high-level policies, leadership by business, by the leaders within a business, consultation with affected groups, the adoption of effective remedial mechanisms, and internal and external oversight processes and auditing. And really, I can't underscore and highlight how important due diligence is within the tech sector as well as other areas. But what we're finding is that when we talk about due diligence, it can often be narrowed to the idea of just adopting some kind of human rights policy within a business, or just talking about impact assessments. So thinking about how we can really have due diligence adopted in its fullest sense would really go far in helping addressing the human rights concerns within the tech sector. But it's not only a question of just transplanting the UN GPs, because even within the UN GPs, there are a lot of issues that we have to work out in terms of what due diligence means. And as I've said, remedies is crucially important, and that is something that is generally underdeveloped in the business and human rights sector. And when you look at it at the tech sector perspective, you can see that the questions of scale, remedies for human rights issues that are across jurisdictions really raise particular challenges, as well as the question of what internal grievance mechanisms mean in the context of the UN GPs, where companies provide grievance mechanisms themselves. Do they work as remedies? What does internal oversight look like? What does that mean? What do we require within companies to identify and address human rights harm? And what are we expecting externally within particular sectors for oversight to be part of a process? And there are a lot of discussions around external oversight bodies within the tech sector and whether they could go to addressing human rights harm that we're seeing. So really, I think how conversations around mandatory due diligence advance within the treaty and outside of it will be really important for the tech sector, in addition to specific tech regulation. But I think I'll stop here for the time.
That's great. Thank you very much, Lorna. If I might just, throw a couple of follow-up questions to you. I think one would be, because your expertise goes much broader than in human rights, goes much broader than the area of tech and AI and the digital domain to sort of the more analog human rights systems and issues, more traditional sort of human rights issues. So I wonder, from taking both your expertise now on sort of digital and tech, as well as your broader expertise on human rights institutions and so forth, I wonder what you think, or how you would sort of formulate, what do you think the role of UN level regulation, can be, should be, as regards, this tech domain? How would you try to sort of define or to capture? Because especially taking the sort of sui generis nature of lots of these tech companies who are, providing actual infrastructure rather than for business activities, rather than just performing business activities, within a sort of market environment, which, a normal market environment, and the complexity and the sort of privacy of what they do, because you have to really be almost inside the company to really know, and inside the business, the individual products, to really know what they're doing to human rights, or what the implications. Taking these kinds of challenges on board, which mean that at the level of general oversight, it's quite hard for regulators, if not impossible, to, not only to keep up with the sort of pace of technological development, but also to access the relevant information to be able to make assessments of, the extent which rights have been appropriately balanced and all. So I just wonder, taking that on, what do you think? How would you characterize sort of the proper role of the UN level, or, in that environment?
Thanks. So I think there's quite a few issues within that question. I think in terms of regulatory initiatives, it has to be multi-layered and multi-scalar. So the UN clearly is one part of that, but we have to be looking at national, regional and international, which obviously adds layers of complexities when you're thinking about regulation at multiple levels. But that said, I think that we can see, for example, within the UN Human Rights Council in their privacy resolutions, that they have started to look at the role of businesses, you know, and have been emphasizing the importance of the UN GPs, of due diligence, of looking at the life cycle of the design, development and deployment of technology. So they've been looking, you know, very much at how do you operationalize human rights principles in relation to states and businesses. And I think that, you know, that type of role is really critical. I think the, you know, the work of projects like BTEC within the Office of the High Commissioner for Human Rights and a range of special rapporteurs have been putting forward, you know, recommendations for really looking at how do you operationalize standards like the UN GPs and how do you take them further. So I think, you know, really utilizing these mechanisms and looking at how you address human rights issues is really important. And also the working group has been looking at these issues. So understanding how you operationalize these human rights principles for the tech sector, but against the voluntary principles of the UN GPs, I think has been a really important role, but one that has to be set alongside a range of other initiatives. But I think the point that you made about, you know, the inside the company. So one of the biggest challenges is identifying when there has been human rights harm, and that's quite a different issue to other sectors where it's very clear that there has an evident and visual that there has been a particular human rights harm. You may not know that your privacy has been affected unless someone tells you. You may not know that your data has been breached. You may not know that you're being profiled through an algorithmic process. You may not know that a state agency is using a company's facial recognition software or particular algorithm unless someone tells you. So transparency is absolutely critical across this. But in terms of internally within a company, it really highlights why it's so important to understand due diligence processes and to understand how human rights principles are applied, and what it means when you identify a potential human rights harm. What is the responsibility of the business at that point? Is it just to report to a board? Or is it to actually go out to an individual or group affected and inform them that there has been a harm so that they can then access grievance mechanisms and remedies and bring a claim? So understanding, you know, how we actually find human rights harm within a company and what that governance ecosystem looks like, because it has to be a very complex ecosystem where many people are able to identify human rights harm, know human rights harm when they see it, and know where to report it. And then the question of how do you develop external regulation so that there is independent oversight that, as you say, is effective and is able to actually see what's going on. And there can be often arguments that, well, proprietary interest means that you can't reveal, for example, an algorithm, but there's certainly systems that can be put in place so that regulators are able to see what's going on without that necessarily being public knowledge. So there are ways around this, but I think the tech sector highlights how important internal processes are alongside external, and the need for these systems to be built in both ways, as well as understanding the state to business relationship, which is really crucial because a lot of these technologies are being used in the public sector, but coming from the private sector.
Great, thanks. That was really, really helpful. I think I would turn next to, and thank you, Lorna, to Brigit Toebes, Professor Toebes, in the food sector and, you know, generally as regards non-communicable diseases and public health challenges in which the corporate sector is implicated, I suppose, you know, the as it were, the problem profile is perhaps quite different. You may not have all these issues around sort of technological complexity, but rather very different challenges. So I'm really looking forward to hearing, yes, how this appears to you as an expert in global health law.
Thank you, Claire. Can you hear me?
Yes.
Well, thank you very much for this interesting opportunity. Yeah, and so I would like to reflect on this.
I can't see you. I can hear you, but I can't currently.
Okay, let me switch the camera on. Sorry, I missed that.
And
okay.
And yeah, all the panelists' biographies are included now in the chat by Ben as they're speaking for the benefit.
Can you see me now?
I actually can't.
But other people should be able to see me, right?
No, people are shaking their heads. I did see you earlier.
Yeah, so I'm probably somewhere at the bottom. It's a little better to see someone when someone speaks, right?
Yes, Ben, I just asked Ben, is this something we encountered previously? Should we maybe ask Brigit to sign out?
Correct. Yes, perhaps Claire. If you'd like to just come back into the meeting, Brigit, that might solve the problem.
So I sign out and I come back. I hope I succeed. Thank you.
With apologies.
Yes, we'll wait for you, Brigit. Well, maybe just while Brigit's coming back, I did have one other sort of question for Lorna, which was around remediation. And one of the sort of concerns that I have is that sometimes the sort of paradigm of remediation
can you see me?
Seems to me, yes, we can. Brigit, sorry, okay, I'll come back to the question to Lorna afterwards since we have you. Okay, back to Brigit.
All right. So an important anchor in my talk will obviously be the right to health and the protection of health, and the notion that the actions of corporations have a huge impact on health. And so I've asked myself, what should this framework treaty offer? I found your questions really interesting and challenging. And the point that I'm going to make is that the framework treaty should take into account the tremendous impact that corporate activity has on human health in many different ways. So I see many dimensions to this. Sometimes the different distinction is made between the internal dimensions and the external dimensions when it comes to human rights responsibilities of corporations. I'm not an expert in your field, so I don't know how authoritative this distinction still is, but I found it useful because internally you see health concerns in relation to the operational dimension of the company when it comes to labor conditions, inadequate occupational health conditions for any business. So that's an important point of concern. But in addition to that, externally, there's also many health concerns. Well, the big debate has been and is still ongoing is of course about pollution, and the big example here is of course the oil industry. The way corporations operate may have an impact on the environment and cause environmental damage and potential damage to health. But in addition to that, there is also a lot of human rights concern and debate about the products and services that corporations produce and offer. And firstly, in the sphere of healthcare, I think there's important human rights concerns. There are many private actors, also international actors in the health sector, varying from private healthcare providers to private health insurance companies. And of course, the aim is that they contribute to the adequate provision and financing of healthcare or to the protection of public health. But we also know that they do not always deliver and that there's many human rights concerns there. There has been a fantastic report from Transparency International about corruption in healthcare that I think is still useful in this context. I think it was published in 2006. And it offers many examples of potential human rights violations. They do not use the word human rights, but it's obvious that it's all about human rights. And if I think about the envisaged treaty, I know the treaty is very much about states should do this and states should do that. I find that very disappointing, I must say. So allow me to be a bit more forward-looking, perhaps, or idealistic or utopian. But I would suggest that this treaty includes a call on, or that these health actors are encouraged to respect the right to health, but also specifically the so-called AAA that we find in General Comment 14, which could then be the responsibility to respect the availability, accessibility, acceptability, and quality of healthcare. Perhaps this is over-ambitious, but I think these kind of seminars are there for us to be a little bit ambitious. Next to that, a whole debate in itself concerns, of course, the pharmaceutical industry, the role of the pharmaceutical industry, which in principle, they contribute to the realization of the right to health, but there's also many problems and tensions. And I'm not going to discuss this in detail, but an important concern is, of course, the high price of some medicines. And I myself am involved in a Dutch foundation called Pharmaceutical Accountability Foundation. And we are seeking to develop cases against pharmaceutical companies based on human rights for the high price of their medicines. And to some extent, we've been successful, for example, in relation to a company called Leuven, with regard to the drug CDCA, which the company had increased with 500-fold its price, of course, after obtaining orphan drug market exclusivity. Now,
sorry, Brigit, there's a little interference with your audio, a sort of clicking noise, as if something is maybe banging. Yeah.
Is this better?
Yes, it's much better.
Okay, so I continue like this. I hope the dog does not start to bark, but okay, we carry on. Now, other dimensions include, of course, the production of falsified medicines. And we can also say that, for example, America's opioid crisis reflects a crisis in human rights in which the pharmaceutical industry is complicit. The pharmaceutical industry too, could be asked to respect the so-called AAA. Now, but speaking about external activities of corporations and the impact on health, we should also address the role of, as you also mentioned, Claire, the role of the tobacco, food and beverages industries that they play in the current chronic disease pandemic that the world is facing. We are witnessing a tremendous increase in non-communicable diseases around the world, so not only in high-income countries, including cardiovascular disease, diabetes, cancers, which are caused to a considerable extent by 4 so-called behavioral risk factors: smoking, unhealthy diet, lack of physical exercise, and excessive use of alcohol. And these businesses, tobacco, food, and beverages industries, are now also actively expanding their markets to low and middle income countries, where people are changing their dietary patterns as a result of this, often with dramatic consequences. Now, so that's also an important right to health concern. So what should this treaty do? Again, I think it's disappointed that it's so very directed towards states and not to corporations directly. I know it's probably not feasible, but okay. In an ideal world, I would like to see a direct recognition of the responsibilities of corporations to respect human rights and the right to health in particular. It could recognize the importance of a right to health and recognize that corporations have this responsibility to respect. And then what does that responsibility to respect mean? And that could, in my view, mean different things in different contexts. For a pharmaceutical company, it could imply maintaining quality standards, but also being transparent about production processes of medicines and about the composition of the price of products. By way of a different example, the tobacco industry, the ultimate consequence of the responsibility to respect the right to health for the tobacco industry seems that they should go out of business, because producing a product that is so clearly toxic and dangerous to health seems a clear violation of the responsibility to respect the right to health. But of course, in the meantime, there's an ongoing obligation to respect human rights throughout the value chain. Also, for example, when it comes to the production process, as there are many concerns there at that stage of the process as well. You are also asking about the experience with framework treaties. So by way of a final remark, let me make a few very brief remarks in light of my experiences with the Framework Convention on Tobacco Control. Overall, what we see globally is that this treaty is a success, as it has led many countries to adopt stricter tobacco legislation. But as a framework convention, it is very open-ended, and that's certainly a weakness in the treaty. At the same time, it's very difficult to set clear targets regarding tobacco control. And what we also see is that when it comes to smoke-free zones, many countries already go beyond the treaty. So smoke-free zones is a specific dimension of the treaty, and there many countries have already more advanced smoke-free zones than the treaty provides for. Last remark, the FCTC, the Tobacco Treaty, as we call it, is not a human rights treaty in the sense that human rights are only mentioned in the preamble, and that seems to be a serious omission. And if I understand correctly, the treaty, the Framework Convention that you are envisaging is going to be clearly a human rights treaty. So I think that's very promising, and I think it's an excellent project, Claire, that you are embarking on, and I wish you lots of luck with that. Thank you very much.
And thank you, Brigit, for that excellent overview of many of the very profound and currently intractable problems in which corporations are implicated, which have got consequences for health and the right to health. I guess just to respond on the point, the very important point you made about direct responsibilities. Here comes the dog. Direct corporate responsibilities. As regards the framework text I proposed, well, they incorporate the UN framework and the guiding principles. So to that extent, the responsibility to respect is integral. Whereas I don't see a role for direct corporate human rights obligations, enforceable at the international level, I think, there are many ways in which you can still approach that, function as a sort of, from point of view of functional equivalence through other elements in a framework treaty. And thank you for addressing the Tobacco Framework Convention in your remarks. And I guess one of the points I find interesting about that is that, it deals with such a relatively narrow topic, how to regulate a single industry, but there is still such considerable diversity among states in how they choose to regulate and the extent to which they regulate and the specific modalities by which they choose to regulate, tobacco use, production, etc. And for me, it's one of the rationale for a framework convention on business and human rights, or a framework style instrument on business human rights, is that, not only do we have to deal with tobacco regulation, but we have to deal with all of the industries that you've mentioned, food and beverage, tobacco, pharma, etc. So when you have to sort of encompass, all market actors effectively in the scope of the treaty, then correspondingly the possibility to achieve consensus on more specific text seems to diminish to me, and therefore you need to have a more sort of open formulation, as is the Tobacco Framework Convention, as you said, is sort of open-ended, and it can be seen as a weakness. Some people certainly see it as a weakness and would like to have and more specific, deep-reaching provisions that regulate states' sort of approach to regulating business in more detail. But for me, this is something that can jeopardize the actual objective of getting the instrument with a wide backing among states in the first place. So I think it's a really good example, and I'm very grateful to you for highlighting also some of these health problems around pharma, etc., which I think often just drop out of the conversation about business and human rights, which can get channeled into a focus on certain topics and certain kinds of human rights violation at the expense of others, which are certainly there and under emphasized currently. And I think non-communicable diseases is an area where business human rights as a field of scholarship still needs to increase its activity and give greater prominence to issues of corporate and state responsibility in that domain. So thank you very much for that. At this point, I think I will hand the word to Gale Raj-Reichert, and what I'm really looking forward to hearing from Gale is how, from a perspective of value chains, global value chains analysis, how does the sort of regulatory problem look here? We've spent a lot of time over the last 20 years. There's been a lot of effort, sort of not just in scholarship, but also in policy, trying to work within the global value chain as a unit of analysis, to recognize it, acknowledge it, see it as being different from the state, and presenting maybe some opportunities, also definitely some challenges for achieving human rights and for the fulfillment and enjoyment of human rights. So how does, this discussion about a global instrument that is still largely sort of state-centric, you can say, in its mentality or in its conceptual structure, how does that seem from point of view of an expert like you in the global value chain field?
Thank you, Claire. Thank you for inviting me to this really interesting seminar. I'm learning a lot being here. Are you able to hear me? Yes. Okay, great. And thanks for the slides. Okay. I would just say we could already go to the second slide. I won't waste so much time with introducing myself, but maybe more just setting out my points that I will make for the topic of the seminar based on the research that I've been doing, which is really to look at, as Claire mentioned, labor governance and global value chains. And I've just put up this little graphic here, really as a very simplified way to give a snapshot of, a part of this complex global arrangement that I've been researching, which is the electronics industry, global value chain, or global production network. What I've been spending my time or my interest in researching this topic is to look at how lead firms or brand firms that are located in the global north or the highly the consumption countries, the large consumption countries, and their outsourcing of manufacturing to production locations in the global south. And a lot of my focus has been on Southeast Asia, but also recognizing there are regional hubs, for example, in Latin America, South America, also Central and Eastern Europe, and then China and sort of countries around the Chinese corridor being also a major kind of regional focus. And next slide, please, Ben. What I've been really interested to understand is how different labor governance processes or tools, and several have been mentioned here already, but largely it's been, self-regulatory voluntary mechanisms such as standards or codes of conduct, how these tools are being transferred and implemented, how they're being received in these production locations by suppliers who at the end of the day have to do most of the work, and then how the data of whether it's having any impact on the ground, whether workers are better off, whether behaviors are changing in terms of outsourcing patterns, how all of this sort of information is being flown back to the brands, if you will. or to campaign groups or the media that are located in the global north. So I'm very interested in sort of what I've circled around these arrows to just understand the processes. And it's based on this that I will make my points, which will start on the next slide. Thanks, Ben. So I'll just make 5 points. And whether they're useful or not, we'll have a discussion about that. But it's based on sort of my observations of what's worked and hasn't worked. And of course, I'm focusing more on what hasn't worked. But I'll start with just making a point about the challenges of reactionary responses. So when we think about how do we govern working conditions or prevent human rights violations in a global industry, there are limited resources. And so what we tend to see is a prioritization of hotspots of violations. At the moment, for the electronics industry, it includes China and the Uyghur population and the problems that are there. A couple of years ago, it was forced labor in Malaysia, but and a lot of these hotspots are influenced by media and public campaigns, and there's geopolitical priorities that inform what we get to see as a main problem at the moment. And the consequences of that, and this is quite obvious, is many problems are left behind. We don't know everything that's going on, but we tend to focus on certain violations in certain locations in the global value chain. The second point, and it's been raised now by the previous 2 speakers, is how do we measure whether improvements are being made? What is progress? There's such a long, such a well-developed system, if you will, of audits and corrective action plans, continuous improvement. So there is, this conduct in place. But do we really know if workers are better off, and based on whose kind of definition or judgment? And so that sorts of questions, I think, also gets raised because of what type of information is being reported back. So that sort of green arrow going back is, what do we actually hear from workers and worker communities to know if they are actually, better off after the application or implementation of a governance tool. And then related to that, related to the first and 2 points is, because we tend to take sort of this location-specific or production location-specific approach, questions about whether we're having, an industry-wide effect as a result of particular governance tools is an important one. So, for example, we might be dealing with the issue in China, but to be fair, a lot of these problems that we see in terms of poor working conditions or violations are structural problems that have to do with the outsourcing model and the business model. And so whether fighting these little fires is actually having an industry-wide impact is an open question. The third point is, if we could have an ideal situation, is to remove all risks of worker exploitation. It starts with understanding who is vulnerable, and that definition of who is vulnerable will change. Of course, it's foreign workers, migrant workers, temporary workers, student workers, and then thinking through what would be the safeguards in place to prevent vulnerability to human rights violations and in different locations as well. And the last slide then is just raising this point about paying more attention to prevention over remedy. And I am not an expert on the guiding principles, so I won't say so much about that. But I tend to see a lot of attention paid to remedies, and I assume that it is a result of the influence of the guiding principles. And the question that I have is do remedies lead to structural changes? So the structural changes around the outsourcing model and the business practices that lead to worker exploitation and human rights violations. And ultimately, it is a question that's posed something like, is the imposition of remedy changing behaviors and the processes which can lead to prevention? So, okay, part of remedies, for one example, is paying workers back for the fees that they've paid to get jobs. But does this actually prevent this problem from occurring somewhere else? Is it actually changing the industry in a way? I mean, is it hitting the firms in a way where they will start to change their behaviors on what's creating the risks that lead to these problems? And the final point, and this has a little bit to do, or actually a lot to do with the research that I'm doing at the moment, but to really focus on the state. And I think maybe this could be a good discussion because now it's been raised also by the previous panelists. But in the electronics industry, labor governance tools have by far been voluntary and self-regulatory. And the track record hasn't been so great. Violations continue to occur. They continue to be exposed. And so strengthening state obligations and mandates over the obligations of firms, I would say, is quite important. And maybe this is where I don't know enough about the treaty to discuss the points that you've raised, Claire. But it can include, I don't know, maybe this is a question, to include market access conditions. And Claire, my research on this a little bit, but to also think through governance tools such as public procurement and the inclusion of social conditions around that. And maybe just one question that I would throw out or would like to ask you if it comes up in the discussion is, how would this framework then connect to all of the sort of supply chain regulations that are coming up in different countries in the EU? Some do have a public procurement element to it, and so maybe I will just end there with that point. Thank you very much.
Yeah, that was marvelous. Thank you, Gale. And I think it's going to provide a very good segue to Axel's comments, since you raised the specter of structural problems, and that I think leads us automatically to think about trade and investment and wider framework conditions that influence the behavior of sort of individual market actors or individual value chains. But before I just hand over to Axel, I wondered, from your broad knowledge across different production networks and value chains, are there any successes, that you can, or relative successes that you can think of where, the goal of prevention or of structural remedies rather than sort of firefighting have been achieved? Or if not, what do you think are the sort of necessary ingredients for, for a form of regulation or regulatory activity that brings that closer?
Oh, the hardest question possible, Claire, to answer. I think, so I would first say, of course, a lot of my research is focused on the challenges. And so I may not be the best person to answer about the successes, but if I could just maybe say what would be factors that would lead to successes. I think one is the ability to prevent a problem from reoccurring in a different location or in a different manner. So I don't know, I would just kind of think hypothetically, if you were to have a success in, for example, on health and safety, to ensure that there are conditions in place to prevent chemical poisonings, for example, in a factory that uses a lot of chemicals. But then you go down a lower tier where those suppliers aren't being focused on, and that happens there. And then you might have more productions being shifted to a lower tier of suppliers. And this is where it gets quite complex, where you don't actually have, a base. Or a floor, a minimum standard of protecting workers from chemical exposure, for example. And so that creates this loophole where you can have this problem being fixed in one location by one supplier in one outsourcing relationship with a brand that might be putting more resources in there, but not in a whole other set of suppliers or other supply chains. So it's this kind of, yes, it's an open play, it's an open marketplace, if you will, of how you want to kind of govern different conditions that workers face. That tends to be the problem. So having, you know, a standard, I think, would be the ultimate, would be one way to see positive change. I'm not sure if that's answering your question, Claire.
Well, no, thank you. It of course it does partly, and I don't think there's any total answers. But maybe Axel Marx can also help us with this question of, you know, whether actually, you know, wider frameworks can contribute to addressing more structural issues, or at least, yeah, and what should be the sort of role, or what could be the potential role of a business and human rights, you know, legal instrument at international level in, you know, nudging trade and investment frameworks, or, you know, even better, reforming them in order better to align with the, you know, the substantive requirements and the ultimate objectives of human rights treaties.
Yes. Thank you very much, Claire. So I will approach it a bit differently, also build a bit on what we already heard with regard to trade and investment, which you also mentioned. There's also, of course, a whole, let's say, development going on where attention for business and human rights is gaining ground. We can think of the integration of these types of considerations in trade agreements, and we're seeing the EU is increasingly doing that. We see it in unilateral trade instruments like the general scheme of preferences, where there's further consideration for business and human rights. So that's already gradually happening. Whether that's working, whether that's effective, there's a whole debate on it, and there's definitely room for improvement. And there are currently actually quite a lot of developments, especially in the EU, which try to strengthen that. But in relationship to our discussions and a possible framework approach or a treaty approach, I would maybe also take the discussion a little bit on a even higher level and approach it a bit from, let's say, what we call a global governance perspective. And taking that approach allows us a little bit maybe to try to connect a lot of things we already heard today and try to distinguish maybe a few trends which are important to consider. We already talked about digital challenges with regard to human rights and the different types of instruments, especially also regulatory initiatives, which might address that. The same with food. Gale talked about labor issues, where you see mainly voluntary initiatives emerging. And what is actually, if we start adding that up, we can actually see that there's a whole, let's say, regime of business and human rights emerging, or a global governance regime. And it's characterized by multiple types of actors who are making basically transnational rules for business conduct in relation to human rights. And these rules vary from being extremely voluntary, as Gale's already pointed out, and several other speakers, to increasingly more and more hard law types of things in reference to due diligence regulations and these types of things. And I think that's a first important development. I do think we see the emergence of a regime, and that regime is consisting now of many different interactive and interacting types of actors. You already referred to the UNGPs and the Global Compact. We have the OECD guidelines on multinational enterprises. We have the action plans, as you mentioned. We have the integration and free trade agreements. We have increasing attention and investment agreements for labor rights and especially human rights issues. We are getting a lot of voluntary initiatives, which Gale mentioned, but if we talk about voluntary initiatives. We're talking about audit regimes, certification systems, and so on. And according to different databases, we have more than 400 of these systems currently active. We have the ISO initiative. We have now in many, especially European countries, initiatives or new regulations on due diligence. In the Netherlands, they focus on child labor. In France, they mainly focus on large corporations. But all these things are let's say, piling up into a complex web of initiatives which feed into one another, which actually interact with one another, maybe not enough. But we do see a regime emerging. And one of the key questions there is, can we consolidate in one way or another the regime? Can we connect the dots, or can we try to maybe make sure that some of these instruments are better in developing substantive guidelines and norms, and others might be better equipped for enforcement and implementation? Can we connect in one way or another these different dots and institutions? And I think that's one of the areas where your idea of a framework convention, but it can also be the treaty can potentially play a role. And there I think it's important to understand that maybe we should not always start adding new institutions and initiatives, but trying to see if we can leverage or strengthen existing ones, and maybe trying to see whether there can be further synergies. Second important element I think we see emerging, and which is also occurring, is what we in global governance literature sometimes call the increasing legalization of the business and human rights field. And I do think, I agree with Gale that many initiatives we look at are very voluntary in nature, but I do think that there is a shift to an increase, let's say, more mandatory responsibility of companies to deal with human rights issues. And that becomes especially clear, I think, in the new due diligence regulations which are going out there. I think it's still wait and see whether they work. We have a few examples. The European Commission will launch a new initiative end of October, which will probably mainly focus on addressing forced labor issues. But there you see a lot of new developments coming out, and we have to try to, I think, assess what that contribution of these different initiatives can be. But we do see that many of these initiatives try to shift from the voluntary approach to the more, let's say, mandatory approach, and also sometimes try to incorporate some of the, let's say, other initiatives which are out there in the global governance regime of business and human rights. And in that respect, I do think that we have to watch very carefully how that's being done. I think Lorna referred to it, that a key component will be about what do we exactly understand on the due diligence, how will it be operationalized, how it will be applied. I do think in the last couple of years we see quite a bit of progress in that respect, mainly led by the OECD with regard to developing, I think, guidelines. I think much more progress can be made, but if you look at, let's say, more the specificity on how due diligence requirements are getting operationalized, I do think we can see some progress in that respect. So strengthening that further legalization of the business and human rights field as maybe a second interesting trend to discuss and see how that might actually be reinforced by the treaty or a framework approach as you propose.
Okay, great, thank you. And maybe I could just come back to you on the question rhetorically that you asked about whether we can consolidate the emerging business and human rights global governance constellation or framework, as you know, one might call it, which comprises all these different elements, some at the company level, some at the sector level, some geographically based. some deriving from specific, institutions and organizations. Do you think we can? Do you think we should? Is it desirable? And, if it is sort of good to try to get this all into a sort of bigger organizing framework, which I think it would be. But, what do you think could be the sort of proper, again, role of a UN level instrument and associated institutions in that project of sort of consolidating and connecting the dots? What's the sort of benefit of doing that? And how should we think about the role of an international instrument in that respect?
It's an excellent question. In a way, we think a little bit like whether we can engineer the world with all these instruments and see whether it works. And I don't have a clear vision on how it would work, but I do think that more orchestration via, or let's say more coordination with new instruments might be one step forward. It's like having a good conductor conducting a symphony. We now have many different instruments and players out there, and if they all play their own game or their own tune, it will not add up to a nice symphony. But if they really can coordinate a bit further, it might. My main, let's say, point or worry or concern is a bit that what I said before. We maybe do not necessarily have to invent new institutions or new tools, but try to strengthen existing ones, because also some of these existing ones have had a long history in being developed and being implemented and so on. And my main approach would be to try to think about how can we strengthen the effectiveness of all the existing instruments which are out there. And can a treaty or a framework approach play a role in there? And one way maybe can be to, but that's just thinking out loud, like we have these non-judicial mechanisms like the OECD national contact points, which can possibly contribute to remedy, but for the moment not do it enough. Can we find ways to strengthen that they contribute to that type of commitment? We have a lot of these voluntary initiatives, and Gale mentioned them, and she's, I think, correctly critical of them, but we also have to acknowledge that some of these voluntary audit types of systems or certification systems have also evolved over time and do sometimes address and have an impact on the ground. And then the question is, can we scale that up? Can we learn from that? And can we actually apply that in different ways? And can, for example, through the integration of international instruments, can that be achieved? Because sometimes we also have, let's say, international coordination to scale up and diffuse models and best practices, and that might also be a role they can play.
Super, thank you. And so I will turn now to Professor Maurice Altman as our final panelist, who comes from within the Dundee Business School. He's the director of the Dundee Business School, and as a scholar within business and management, I think I hope this hasn't sounded all very peculiar. It's a lot of people sort of talking about business, whereas perhaps you're more closely linked to business. I wonder if it seems a very foreign conversation, or what do you know from your own work as a business ethicist about whether the things that we're talking about and proposing and the assumptions we're making, are these valid? Does any of it stack up, or does the world look very different from where you're viewing it?
Thanks, Claire. I'm having trouble sharing my PowerPoint, which I all prepared very nicely to share, and now it's not sharing. So just hang on a second, and let me get the right slide. Somehow it disappeared. Let's see. Okay. I think I got it back. Let me try to share it. Okay. Is that working? No, it's flipping out. Okay. Anyway, maybe this won't be successful. I'll forget about the slides and I'll just go to the presentation. How's that?
Maybe if you select, I think on Teams you have to select your window. If you select the PowerPoint window.
Yeah, I did, and it keeps flipping to another PowerPoint.
Oh.
I'll try it one more time. It doesn't work. It's no worse. It's no point.
We see it now on human rights and socio-economic well-being.
Oh, you see it?
Yes.
Yes.
Oh, finally. Okay, good. Now I'll see if it's okay.
Yes.
Okay. Okay.
That's
Fine. Good. So I'm not sure how useful my comments will be, but coming from the point of view of an economist, and I've been looking at some of these issues, for a while. But just some overarching points made to put things in context. I think it's important to recognize over the past 30 or so years, deep poverty in the world has collapsed, basically, and this has been led by changes that have occurred in China and in India. So basically, deep poverty encompassed about 90% of the population of both China and India, and now it's less than 10%. Not perfect, but one can link some of these changes to labor rights with regards to mobility of workers, and property rights, all of which are embedded in the United Nations Declaration of Human Rights. And just in terms of what other people have been saying, in terms of human rights and human rights in business, if you wish, it's critically important to appreciate the importance of transparency and accountability and the empowerment of workers. And another point I'll just make towards the end, of women in the world economy. And finally, just flowing from what other people are saying, I think when we talk about regulation, I'm not a great fan of over-regulation, but regulation that's in place needs to be effective regulation. And effective and efficient regulation, I think, is what can really enhance the well-being of workers and small, medium-sized businesses, peasants, farmers, which are farmers, of course, are very dominant in poor countries of the world, including actually in China and in India. So let me just first start off. So going directly to the PowerPoint, if you can still see it. So there are a number of articles in the Universal Declaration of Human Rights, which have, I would argue, significant implications for the economy. Implications for how businesses go about doing business, producing goods and services, and also with regards to government policy. A lot of the way governments regulate or hope to regulate or enforce human rights regulations or not enforce them, which is typically more the case, is that flowing from conventional economics, which is what people are taught in school or what government advisors typically hire, would argue that many of the points or articles of the Universal Declaration of Human Rights are incompatible with economic growth, with improving the size of the economic pie, and with increasing valued employment in the world economy. In other words, if you enforce human rights articles, you're going to damage the overall economy. So one has to be very, very careful. It would be very nice, the conventional economists would say, to implement and enforce a whole set of articles with regards to human rights, but there'll be a whole bunch of negative consequences for the economy that one should be aware of, or so the argument goes. So what I would argue, and I'm not a conventional economist, so what I would argue, and this is based on analytical frameworks which I've developed over time, is that abiding by various, not necessarily all of the human rights articles can actually facilitate a more productive and efficient economy. And for this reason, this can thereby contribute to improve the well-being of all members of society, especially the most vulnerable members of society. So it's not just to say, oh, it would be very nice if we have all these human rights articles enforced, but remember all the horrible costs that this might imply. I argue, well, actually, labor rights, for example, and gender rights, if well and effectively implemented and operationalized, can have a very, very positive effect on improving the material well-being of the world's population, once again, especially the most vulnerable people. And of course, that's vitally important. It's although some people would argue, economic growth is not the only game in town. It's not, but it's vitally important because you want to eliminate deep poverty, you want to eliminate starvation, you want to increase life expectancy, you want to decrease mortality rates. That's all important. However, one thing one should mention is that the relative power, the relative wealth positioning of the wealthiest members of society might very well deteriorate, even if their absolute standing remains the same. So at least in some of my work and that of others, you will find resistance to enforcing labor rights, labor standards, health standards, etc., quality standards in terms of the workplace, even if it causes no harm to those people, no absolute harm to those people in power, because what motivates a lot of people is their relative positioning in society. And God forbid you touch their relative standing, they will resist. And that's why over the past 2.5 centuries, there's been an ongoing struggle of peasants and workers to make things better, and that generates all sorts of changes in the way people look upon the world. So the next point I want to make is, I just related to what I said before. The standard model is that if you improve conditions of work, for example, this will increase production costs, unit production costs. It will make the cost of wheat increase, of dairy products go up, of electronics, of clothing, carpets go up. This will make firms less competitive. And if this makes firms less competitive, people will be unemployed, there'll be more poverty, all these bad things will occur. But I argue that this, and this is backed empirically, that this is not the case. So basically, human rights can generate the incentives to, very often with government support, can spur firms towards being more productive, more efficient, and also induce technological change. And all of that, so this incentivizes growing productivity, but it incentivizes through human rights, labor rights, growing productivity in such a way that workers capture the benefits of increasing productivity. It's not a trickle-down effect. Eventually, don't worry, peasants and workers and farmers, eventually you'll benefit through instituting labor rights. Workers directly benefit because they're part of the process of incentivizing growth and development. And I'll just throw in one quick point, is that cooperative organizations, worker-owned cooperatives, farmer-owned organizations is a fundamentally important way, we know from the evidence, of improving the conditions of workers, and is quite consistent on in terms of the United Nations articles, some at least, the United Nations Articles of Human Rights. So overall, human rights is not a burden, should not be viewed as a burden on the economy and on improving the well-being of our population or populations. It rather contributes towards increasing the size of the economic pie. And I'll just identify 2 points because it's become important more recently. If you look at China, a long time ago, and even in India, there were very strict restrictions on labor mobility. Peasants had very little claim on their property. Well, it wasn't really their property. It was communist it was run by the Communist Party, let's say. And so if people really worked very hard and improved their farmstead, those gains were very often captured by the state or by bureaucrats, people who are actually quite wealthy. And very often, this is similar in India. It was through allowing for more labor mobility and property rights. I'll just speak of for farmers and small businesses that played a fundamentally important role in transforming China into a country which was still full of problems, but was able to solve some of the horrible issues related to poverty, especially in rural areas. But there's a long way to go, and it's interesting. We're talking. Well, I'm in Scotland, and Claire's in Scotland. Some of these insights came from Adam Smith, who was not only talked about political economy, but about the moral economy, and about how empowering people, empowering the peasants, empowering the workers, and very often that was through more trade and growth, is what would facilitate benefits to them. So this is in a world without unions, which is another important area that needs to be talked about, but can't talk about it right now. Now, the other point I'm seeing, I have maybe 2 or 3 minutes, maybe 2 minutes, whatever. Another area I just want to touch upon. So human rights, another important aspects of human rights and labor rights, it improves the chances that individuals can realize their preferences. In other words, their wants and desires, from the number of children to have, the education, how much they want to save and how much they want to spend. And human rights, therefore, so this has nothing to do with production per se, it can contribute and should contribute to improving the overall level of happiness of a large segment of the population, where without those rights, their preferences and their ability to actualize their preferences become stymied or blocked or reduced. And so just one example, I don't know if people are aware of the work of Martha Nussbaum, who's an action philosopher, if you wish, and Amartya Sen, who she's written with and who've pioneered what's been referred to as the capabilities approach. And basically, if you think it's just about women, so women typically women would typically not want to have 10 children. In certain circumstances, they would prefer to have 5 children. But if they were not empowered to have the number of children that they would prefer to have, in other words, related to their true preferences, then population growth would be much greater. There's a whole bunch of reasons why in a poor country, even women would want to have 5 children as opposed to 2, because 3 of their children would end up dead probably based on the statistics. But in terms of human rights and gender rights, and the last point I'm going to make is on gender rights, is that if women have the education, the right to education, same as men, have the right to realize their preferences for the number of children, what happens, and this is backed by the evidence, is even in the poorest countries, population growth rates collapses. So this is just one example, but an important example of how human rights can positively impact on preferences, which in turn positively impacts on population growth, which in turn has significant implications for the economy. Now, if I have 1.5 more minutes, I'll be finished. Sorry, is one of the keys to unlock the wealth of nations is basically the protection of women's rights. And I think, well, in our current, it seems that's something which we don't pay enough attention to increasingly. So basically, even the basic right of women to work and to receive a basic education, basic university education, but more importantly, basic technical education, has dramatic effects on the economy. And actually, if you look at various economic models, whether it's conventional or non-conventional, most economists would agree on this, that the basic rights of women to work to look for a job wherever they want to look for a job, and the right to get a job on an equal basis when competing with men has huge economic implications. And of course, it's not sometimes when you talk to people in universities, or people don't seem to always realize that women make up at least 50% of the population. And therefore, it's so very important to understand this. So when women were locked out of the workforce, this will have a very large negative effect on productivity and well-being. And basically, if you look at the data, one report, for example, on the MENA nations, the Middle East, North African nations, is one of the fundamental causes for low levels of growth, productivity, and high rates of poverty is the exclusion of women, not in every single country, but the relative exclusion of women from the economy. And one very quick example, then I'll be quiet, is that if you think of it, if you only hire men, you're going to hire the most qualified men and actually not very productive men. And what you leave out are all those women who are more productive and more qualified than the least qualified men. So if you introduce women into the workforce and you give women a fair shake, as you would give men, you end up hiring the best people for the job. And just in terms of the arithmetic of it, that has a huge impact on productivity and growth. And that's one reason why a lot of, it's not only Western countries, but countries, say in Europe, Canada, United States, where gender rights have, after a lot of struggle, come to fore, not perfect yet. That's one reason why a whole bunch of countries are doing much better than a whole bunch of other countries. Anyway, it's enough said.
I think that's a great place to stop. And rarely in business human rights discussions, I think, do we end on a kind of upbeat note. But I think this makes a nice change in that respect. And thank you very much, Morris, for, I think, providing some of the economic analysis and evidence to corroborate, which probably, many of those of us who've been active in the business human rights field, I think, have had as instincts without necessarily being able to, substantiate those instincts through kind of economic scholarship. So thank you for that. Now, we don't have so much time left for questions. I wonder if I should turn over now to the participants. I didn't see any questions appearing in the chat during the previous presentations. Does anybody who's listening have a question for any of the panel? It seems not, in which case I will also open to perhaps the panel in case you had any questions for each other or final remarks, just in a really brief couple of minutes, because I do want to be respectful of both panelists and participants' time, and we have come to the end of our allotted hour and a half. No. Okay, well, thank you, everybody. It's been a very broad-ranging discussion. I think Ben is just putting into the chat details of next week's seminar, number 5 in the series, where we will be hearing from Professor Larry Kadabaker from Penn State, Professor Dorothy Baumann-Pauly from the University of Geneva, Dr. David Birchall from London South Bank University, Jerne Cernik from the Nova University in Slovenia, Sorka MacLeod from Copenhagen University, and also Dr. Miho Taka from Coventry University. And there we will be addressing, I think, actually, probably what was most highlighted by Axel's comments today, which is this question of how to link a new UN instrument, whether it's a framework convention or somewhere on a spectrum between a human rights treaty and a framework convention, how to link such an instrument to these already existing initiatives, governance mechanisms that have emerged over the last 1 to 2 decades. How can we articulate those? Can we coordinate? And if so, how should that be achieved? What should be the sort of pitfalls or things to prevent weaknesses in that approach? How can we optimize the sort of overall coordination articulation? So that will be the focus for next week's discussion. Thank you very much to everybody who has participated. And again, to our panel, it's been lovely to see your faces, even if not in person. Bruno, okay, one quick question, just since you're the only one, I feel obliged. Bruno, please go ahead and ask your question if you can do it right now.
Thank you very much. Sorry for the delay. So my question would go for Professor Lorna. I would like to hear more her opinion on the potential of human rights by design techniques, for instance, because I think that's something that we didn't cover very much today. Is there any potential to help in the problems of identifying the risks to human rights? Because I know that she highlighted that it's hard to do that exercise of seeing beforehand what are the risks and the extension of the risks. So coming from that premise, what is the potential of human rights by design techniques and approach? Thank you.
Thanks, Bruno. Thank you.
Thanks so much for that really important question. In the brief time that we have, I would say that it's an issue that is important not to imagine can address everything, because human rights by design will not address when products should not be developed in the first place, and cannot deal with the whole life cycle. But it's a really critical part of thinking about how businesses can meet their human rights responsibilities, and being able to really work with design teams in the tech sector, engineers, but also leads within companies to really understand how to identify and how to see when human rights may be at risk at the very conceptualization stage of the development of particular products or technologies, and as they are developed and deployed. So really trying to embed human rights principles within the life cycle of technologies is really critical, and being able to enable different people who work in businesses to be very familiar and understand human rights issues so that they're able to prevent them and identify them when they're occurring, rather than solely relying on oversight bodies is really critical. But quite a big conversation around how to actually really go about operationalizing those principles. But I think it's just so critical to not approach, to think about businesses as just an entity, but to think about it as entities and people, and to be able to think about how different people within businesses can effectively engage with and work with human rights principles so that the business as a whole can really ensure the protection of human rights.
Yeah, another great note to end on, Lorna, and hopefully, yeah, we'll be able to return to that theme in next week's seminar. So finally, yeah, reiterate my thanks to everybody, and obviously this is an ongoing conversation. I look forward to speaking with you all again next week and beyond. Bye-bye.